Welcome back to the Constitutional Clarion. I do apologise, it's been quite a long time in between videos, but it's just been one of those problems of having too much work and not enough time towards the end of the year. But anyway, I am back now, and to start off again, because there's lots of things to talk about, I thought I might deal with the topic du jour, which is the High Court's decision in a case called NZYQ, which was about the release of a person in immigration detention because he could no longer be legitimately held because there was no real prospect of deporting him. As you know, there was a lot of controversy about it. A number of other people were released as well, and at the time of making this video, there is discussion about law legislation going through the Parliament to deal with the issue. In this video, I'll explain to you the judgment in the case of NZYQ, so you have a better idea of what actually the court said, and that can give you better context to the controversy that's going through Parliament at the moment. Now, in NZYQ, the High Court went back and referred to its seminal judgment in 1992 in a case called Lim. Now, that case concerned people who'd come to Australia by boat, who were described as designated persons, and an attempt to keep them in detention. And one of the sections that was under challenge in that case was section 54 capital R. And it said a court is not to order the release from custody of a designated person. Now, a majority of the court in that case, that's Lim, said that section 54R was invalid because it instructed the court not to order the release of persons, including those who were unlawfully held in detention. This interfered with the judicial power of the courts and their ability to review the validity of executive action, that power, of course, being one given by the Constitution itself. So it therefore breached the constitutional principle of separation of powers. Critically, however, in the Lim case, the court discussed fundamental principles about when and who can detain people in custody. And it's those principles that the court in NZYQ went back to and relied on. And in particular, they pointed out three different principles that they relied on in this case. Now, the first one is that the executive government can only detain a person if it is authorised to do so by legislation. Okay, so you need Parliament to give that power to the executive. It does not otherwise, of its own volition, have the power to detain a person. Second point is that the involuntary detention of a person will ordinarily be regarded by the courts as punishment. And as such, it is something that only the courts can do in performing the judicial function of judging you guilty of a criminal offence and imposing punishment. But, however, there are some exceptions, and we'll come back to them later, where for other purposes a person can be detained and it's not regarded as punishment. So hold that for a second, we'll come back to that one. The third point, however, was about a particular exception in relation to non-citizens, and that was that non-citizens can be detained for the purpose of deciding whether to admit them to the country, so that's the making of the decision about whether or not to give them a visa, and secondly, holding them for the purposes of deporting them when you've decided not to give them a visa and you want to remove them from the country. Now, in NZYQ, the High Court said that a law authorising executive detention must limit the duration of that detention to what is necessary to give effect to a statutory purpose which is reasonably capable of being achieved. So you actually have to be able to achieve the purpose to say that's the purpose for which you're doing the detention. And the court explained that where there is no real prospect of the removal of the non-citizen becoming practicable in the reasonably foreseeable future, then it cannot be said that it is for the purpose of making that non-citizen available for deportation. It is not for this purpose if the purpose cannot be achieved. It must therefore be for another purpose and the default purpose recognised by the court when you're being detained by the executive is punishment. And of course, punishment is something that only can be done by the court because of the Constitution. So how then, you might ask, well, how does a court decide whether or not a person is able to be deported in the reasonably foreseeable future, and therefore if they can't be, then they're being punished and illegally or unlawfully detained? Well, the court looked at it in terms of two different stages. First of all, the detainee must establish to the court that there is reason to suppose that their detention has become unlawful. Now, if they can establish that, then the burden shifts to the Commonwealth, and it's the Commonwealth government that has to prove before the court that there exists a real prospect of the detainee's removal becoming practicable in the reasonably foreseeable future. And if it can't do that, then the detainee is being invalidly held and must be released. Now, the court stressed that this does not mean that the non-citizen has a right to remain in Australia. For example, if circumstances change and he or she can be deported, the person can be brought back into custody and held until that deportation occurs. There are also other exceptions, however, which I mentioned earlier, that the High Court has recognised where a person can be detained and it's not for, or not deemed to be, for the purposes of punishment. Now, the first obvious example is that you can be arrested on suspicion of committing an offence, and you can be held in custody after your arrest, and sometimes all the way up until the point of your trial and a decision as to whether or not you're guilty. Although that detention does have to be under the supervision of a court, and usually a court is able to decide whether or not to give you bail. Now, two other important exceptions are when a person is detained for reason of mental illness, and that may be to protect the person themselves, or it might be to protect others from that person. And the same is the case in relation to infectious disease. So we saw that during COVID pandemic, that people can be detained if they have an infectious disease or might have an infectious disease that could infect others and is dangerous to the community. Now, both of these cases, the purpose is not punishment, the purpose is protection. Protection of the individual or protection of the community from the individual. Now, there are also some odd historical anomalies. So, for example, military tribunals can detain people for the purposes of giving effect to military discipline, and sometimes parliaments can also detain people if they've committed contempt of parliament. And there's also other possible exceptions, for example, during a war. So the internment of enemy aliens during a war is an example of a purpose for which you could detain people. Now, in NZYQ, the Commonwealth argued that another exception was the detention of non-citizens just for the purpose of keeping them separate from the Australian community, so they don't enter into the Australian community, which is something that's been argued about quite a bit in the Parliament recently. And so that was put in the case, and the High Court rejected it. It said that this purpose lay outside the range of purposes that were permitted in the exceptions to the Lim case under the Constitution. The court said that detention by the executive will be regarded as punishment by default, and therefore something that only a court can do, unless it is justified as reasonably capable of being seen to be necessary for a legitimate and a non-punitive purpose. Now, to be legitimate, the court says it must be compatible with the constitutionally prescribed system of government. That means it has to be compatible with our system of democracy and the sorts of rights that we hold, our common law rights under our democratic system. And the court also stated that to displace that default characterisation of detention as punitive, a purpose must be regarded as exceptional. So it's only in very rare circumstances that you can detain a person for a legitimate purpose where it's non-punitive. Now, at the end of its judgment, however, the court noted that just because the Migration Act no longer authorised the detention of NZYQ, this did not mean that he could not be detained on some other applicable statutory basis, such as under a law providing for preventive detention of a child sex offender who presents an unacceptable risk of reoffending if released from custody. And so this is the small area, the small chink in which both government and opposition are now focusing their attention. So such laws do exist at the state level to deal with serious offenders whose release poses an unacceptable risk to the community in rare cases. So, for example, in New South Wales, the Attorney-General can apply to the Supreme Court for what's called a continuing detention order for a high-risk sex offender or a violent offender whose sentence is about to expire. So this happens while people are still in jail before they're released at the end of their sentence. Now, if the Supreme Court is satisfied to a high degree of probability that the offender poses an unacceptable risk of committing another serious offence if not kept in detention, it is entitled to make such a detention order. But it's limited to a maximum period of 5 years, and it can also be reviewed by a court. And obviously the court has to go through a process where it takes evidence from psychiatrists and other people as to whether or not the person is likely to reoffend. An alternative is for the court to make what's called an extended supervision order. And this is one where people are supervised in the community and monitored, including by the use of electronic monitoring equipment, so ankle bracelets, etc., curfews, all those sorts of things as well. So that's another way of dealing with the situation. But such orders are actually only made in fairly rare cases. So on the 1st of January 2023, there were only 3 offenders in New South Wales who were subject to an order that detained them on this basis. But there were also 147 others who were subject to an extended supervision order in the community where they were being monitored. Now, the purpose of these laws is the protection of the community, not the further punishment of the offender. They're therefore treated as non-punitive. There have been numerous challenges to these laws in the states, mostly in relation to slightly different schemes that are directed at bikie gangs and serious organised crime to try and break up that kind of system of crime. Now, some of them have been held to be unconstitutional and some of them have survived. So the ones that now exist at the state level tend to be ones that have taken into account all the various considerations that a court has applied in these constitutional challenges. Now, what does that mean? Well, the Commonwealth, if it is going to legislate to try and impose a preventive detention regime in relation to people who've been released as a consequence of the NZYQ High Court decision, will have to be really careful to ensure that the courts retain their full discretion to act judicially and fairly in making these orders, and they have to be for the purposes of protecting people, not for punishing people for being unlawful non-citizens by detaining them. And that's why any legislation imposed by the Commonwealth will have to be really carefully considered. It would have to fall under one of the powers that were allocated to the Commonwealth under the Constitution. So there's a real issue as to whether or not the aliens' power would extend far enough to be able to do this. And it would also have to be directed at each particular individual and what they had done and what the particular risk was in relation to that person. So it really can't be done on a job lot to put all the people who were released as a consequence of the NZYQ decision back into detention, because that would be doing it solely for the purposes of punishment rather than genuinely for the purposes of the protection of the community. Now, I'm recording this video before any bills come out. It's been suggested there will be a bill on this next week. So perhaps I'll have something further to say when a bill has been produced and maybe passed by the Parliament, and will probably be challenged as well. But for present purposes, this is just an explanation of what the legal position is in the High Court in the judgment of NZYQ to ensure that you are better informed. Finally, my point here is that because this issue needs to be so carefully dealt with, there are lots of constitutional traps that such legislation can fall into and end up being struck down as invalid. My sympathies go to the poor Commonwealth Government lawyers who are being put under enormous pressure to produce this legislation extremely quickly and in a really toxic political environment. It will be very, very difficult for them to produce constitutionally valid legislation in that context. So sympathies to them. And to you, may I say thank you again for watching the Constitutional Clarion. I hope to inform you of constitutional matters as they arise, including probably any such legislation resulting from NZYQ. Thank you for watching the Clarion, and I'll see you next time. Goodbye.